against this, the writ petition has been filed against the order of the Waqf Tribunal before this Hon'ble Court, challenging this order. 1.17 is the कब्रस्तान और फिर 55 में से 1400 मजार वर्ग फुट इट इज इन दी कब्रस्तान नगर अजयगढ़। जो प्रबंध व्यवस्था कब्रस्तान अजयगढ़ भी आता है, जो खसरा नंबर पे वक्फ संपत्ति के रूप में वक्फ बोर्ड में पंजीकृत है, जिसका मध्य प्रदेश राजपत्र में प्रकाशन हो चुका है। That order was passed by the Waqf Tribunal. That is an interim order, my lord. What has happened, my lord? The land was registered as a Waqf land for the graveyard purpose, my lord, for burial of the dead bodies, my lord. And my lord, one interim order has been passed. That was P18 WP, my lord. It was that, my lord, till the next date of hearing. I am reading, my lord, प्रतिवादी आगामी तिथि तक वादग्रस्त कब्रस्तान खसरा नंबर 100 में मुर्दे दफन करने में रुकावट नहीं करेंगे. This was order was passed against respondent 1 and 2, my lord. And against this, the writ petition has been filed against the order of the Waqf Tribunal before this Hon'ble Court, challenging this order 18/12/20. Now, my lord, in the petition, my lord, two grounds have been taken by the petitioner, my lord. First of all, that the interim order, my lord, and second one is the question of that the Waqf Tribunal has no jurisdiction to hear the matter. On these two grounds, my lord, the petition was filed, and it was allowed, my lord, only relying on the basis of one panchnama, my lord. And one judgment has been passed by the apex court, my lord. That was the Rashid Wali Beg, my lord. It says, my lord, that the judgment that whether there is any dispute, whether it's a property of Waqf or not, the exclusive jurisdiction has to be here and decided by the Waqf Tribunal, my lord. In this case, if lordship may see the para 21, my lord. In the present case, when examined, there is a fact-finding report, Panchnama, of the land was in possession and use of the member of the Valmiki Samaj for burial of their deceased. Taking into consideration, the land is recorded as a government land and cannot be considered as a Waqf property, especially when no document produced by the respondent. Since there is no mention of property being decided by the Muslim community in column number 12, it is the only mentioned Qabristan Madhya Pradesh, unless it is decided by the Muslim community recognized by Muslim law. The implication of law cannot be said to be Waqf property. When there is prima facie, it is not a Waqf property, then the remedy for them is to before the Waqf Tribunal, not the Waqf Tribunal, before the. Now, my lord, in this case, my lord, lordship may come to page 19, my lord. We have already said in our plaint, my lord.
This property is in the name of the Waqf.
Yes, my page 19 may kindly be seen.
The title?
My lord, page 19, my lord. There is a gazette notification.
19.
Yes, my lord. 19 page. Yes. As per section 5, my lord, it was the gazette was published and it was notified as a Waqf, my lord. What section 5 or 6, and on the basis of, my lord, may kindly see खसरा नंबर 55 में से पार्ट है सर, वो 1.17 is the कब्रस्तान और फिर 55 में से 1400 मजार वर्ग फुट इट इज इन दी कब्रस्तान नगर अजयगढ़, जिला पन्ना, अजयगढ़, कब्रस्तान नगर अजयगढ़.
This document was before the writ court.
This document
Para 16 we've seen very specifically objected by the government, my lord. May kindly see para 16 of this order. If my lord may permit, I will read it.
Panchnama was relied.
Right.
But
This, my lord, how this part has been dealt, my lord, our contention has been taken care of by the honorable court, my lord. May kindly see para 16, my lord.
where is just in this document? Where is the Waqf name?
My lord.
Waqf board name is where? In this Khasra number we are talking about.
Yes, my lord.
Where is the name of the Waqf board?
My lord, it is the notification. Again, I will read it, my lord. Page 19, my lord.
Page 19.
My lord, वक्फ अधिनियम, I am reading. वक्फ अधिनियम 54 की धारा 5 के अंतर्गत शासन द्वारा वक्फ बोर्ड को भेजे गए सर्वेक्षण प्रतिवेदन का परीक्षण अधिनियम की धारा 5 की धारा के अंतर्गत वक्फ बोर्ड के द्वारा किया जाकर वक्फ बोर्ड में बैठक इतने में निर्णय गया कि वक्फ अधिनियम 54 की धारा 5(2) तथा उसके अंतर्गत मध्य प्रदेश वक्फ रूल के अंतर्गत 4 के अंतर्गत सर्वेक्षण प्रतिवेदन के आधार पर तैयार गई सूची मध्य प्रदेश राजपत्र में प्रकाशित की जाए. तदनुसार निम्नलिखित सूची सर्वसाधारण प्रकाशित की जाती है. And therefore, the survey list was there and it was recorded as a Waqf, my lord. If lordship may have a look at section 5 and 6, my lord, of the Waqf Act, my lord.
Oh, but Waqf cannot be the owner of the property.
My lord.
Waqf is the only custodian of the property, not the owner of the property.
Yes, my lord. It is a board, my lord, but it's a property registered before the Waqf board, my lord.
Okay.
So, my lord, what my submission? The order was and the suit was pending, my lord, to decide that issue. And then, my lord, this single bench has decided and come to the conclusion that it is not a Waqf property, my lord. It's a question of, my lord.
Because you mentioned that civil
Yes.
suit is pending and that you shall pursue with the civil suit.
Yes.
My lord, now I will come to the regarding the jurisdiction, my lord. My lord, there is a judgment, my lord, if lordship may have a look, my lord. There is a judgment reported in 2020, my lord. That is the latest decision of the Rashid Wali Beg and the judgment of Ramesh Govind, my lord. that is reported in 2020, volume 4 SCC. Now, my lord, may kindly come to this para 14 of the learned single judge, my lord. We have cited this decision and it has not been considered in para 15. If finding is there, my lord. Reading from this judgment, it is submitted that the Supreme Court has held that Section 6(5) of the Waqf Act bar the institution or commencement of the suit or other legal proceeding in a court relating to question referred in subsection 1 of Section 6 speak only about two questions: whether a particular property is specified as a Waqf property in the list of Waqf. So P19 is the list of Waqf, my lord, and nor whether a Waqf is a Shia or Sunni, since the determination is made whether a Waqf property.
First come to the order dated 18/12/2020.
My lord.
That is
Passed by the tribunal, my lord. It's the interim order, my lord.
Yes.
Only this interim order was challenged, my lord. That was a temporary arrangement that they may not be destined for the burial of the dead bodies.
रुकावट नहीं करेंगे.
But this was challenged. Only this was challenged, and the entire, my lord, the jurisdiction and the suit was pending by this society.
In this case, only interim order is there.
Yes, my lord.
But you will not stop them in crimination of the.
Yes, my lord. This was challenged by.
This was the order passed. And by the writ court,
Right.
sir, you take the remedy available under.
And the entire, my lord, the suit which was filed before the tribunal, that was also, my lord, quashed on the ground that there is no jurisdiction to the Waqf tribunal. This is also the finding, my lord. And this order was also revisable, my lord, under section 83(9), my lord.
Yes, what you have to say?
Madam McKinley, but this the revision. I'm just starting from the point of maintainability. Madam McKinley, come to paragraph number 12 of the order, my lord, where, my lord, the Honorable Writ Court has dealt with this issue.
Which para?
Well, para 12, my lord, at
12.
internal page number 5.
Yes.
Subsection 9 of 83 of Waqf Act 1995 deals with constitution of tribunals, etc., and provides that no appeal shall lie against any decision or order, whether interim or otherwise, given or made by the tribunal. It further provides that the High Court may, on its own motion or on the application of the board or any person aggrieved, call for and examine the records relating to any dispute, question, or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality, or propriety of such determination, and may confirm, reverse, or modify such determination or pass such order as it may think fit. Thus, it is evident that the revisional jurisdiction is to be exercised by the High Court. And nomenclature, be it civil reason or a miscellaneous petition, is not important. Therefore, while deciding the case, this court will be conscious of its limitation of deciding the case in terms of the proviso given below subsection 9 of section 83 of Waqf Act 1995. Now, my lord, I'm just coming to para number 16, where the Honorable Court has dealt with the issue. Or, my lord, I will continue with the findings of the court, if my lord may permit me. I'm reading the paragraph number 14, where Rashid Wali's judgment has been, as per the decision of the Honorable Supreme Court in case of Rashid Wali Beg is concerned, it is held that Waqf Tribunal has jurisdiction to decide any dispute, question, or matter relating to Waqf or Waqf property and matter in respect of which jurisdiction of civil court is excluded, and the matter in respect of which jurisdiction of civil court is not excluded. Reading from this judgment, it is submitted that the Honorable Supreme Court has held that Section 6(5) of the Waqf Act bars the institution or commencement of suit or other legal proceedings in a court in relation to any question referred to subsection 1. Subsection 1 of section 6 speaks only about two questions, namely, whether a particular property is specified as a Waqf property in the list of Waqfs is a Waqf property or not, and whether a Waqf is a Shia Waqf or Sunni Waqf. Then it held that since determination is to be made whether a property is a Waqf property or not, therefore, tribunal has the jurisdiction to hear and decide such disputes. At this stage, so-and-so advocate submits that White Annexure P9, this is the document we have placed, madam. Information furnished by Tehsila and Information Officer Ajaygarh District Panna. It is notified that as per the revenue records of Ajaygarh Nagar Panchayat, no land is found to be registered or recorded in the name of Muslim Waqf Committee. Placing the lines on this document, London Comment Advocate submits that when no property is registered in the name of Muslim Waqf Property Committee, then the question of that land being a Muslim Waqf giving jurisdiction to tribunal is not made out. It is also submitted that government land cannot be given in Waqf by any party, and unless the finding in the revenue records that the land is recorded in the name of government is put to challenge by the private respondent, till then it cannot be construed to be a Waqf property. Now, the petitioner has relied upon the judgments in respect of this, my lord. Now I'm just drawing my lord's kind attention to the paragraph number 21, my lords. It is relevant. May I, my lord, if my lord may permit?
Yes.
In the present case, when examined, then there is a fact-finding report and Panchnama that 0.32 hectares of land was in possession and use of the member of the Balmik Samaj or for burial of their deceased. Taking these facts into consideration that the land is recorded as government land, it cannot be considered to be a Waqf property, especially when no document is produced by the respondent to demonstrate registration of the property as a Waqf, property, since there is no mention of the property being dedicated to the Muslim community and column 12 of Khasra entry. It is only mentioned as a Qabristan, Madhya Pradesh, Shashan, unless it is dedicated to the Muslim community for any purpose recognized by the Muslim law, then by implication that land cannot be said to be a Waqf by implication, and therefore when prima facie it is not a Waqf property, then remedy for parties is not before the Waqf tribunal but before the civil court.
But this property is in that list which he has shown.
That is, and that's why my lord, my honorable Red Court has specially mentioned that, that it is only mentioned as a Qabristan, Madhya Pradesh, Shashan, my lord. So, my lord, I'm just coming to that. As far as section impute order is concerned, when it is examined in terms of proviso of section 9, so and so, it is evident tribunal was acting in utter haste. Tribunal committed an illegality in passing the impute order without waiting for service of notices on the respondent. It is also failed to take into consideration the report of various revenue functionaries which had categorically mentioned that Balmik community using part of the land for burial of their deceased, and therefore such blanket impute order directing the respondents to not to cause any interference in the burial of the members of the Muslim community on land measuring 1.206 hectares situated at Khasra number 55 was contrary to the interest of the members of the Balmik community, and therefore that order being cryptic and being passed in utter haste without waiting for service of the notices on respondents, for which case was fixed on 23/12/2020, that order cannot be given a seal of approval. Accordingly, under order dated 18/12 passed by the so and so.
Except that what the community is using for the burial purpose.
Miles.
Right. And whose property is this?
This is it says, my lord, it's a Shashan named as a Qabristan of Shashan, my lords. This is what the finding of the Honorable Red Court.
Where is that document?
My lord, that is, my lord, we kindly see. And in paragraph number 21, my lords.
Yes, 21.
Since there is no mention of property being dedicated to the Muslim community, and in column number 12 of Khasra entry, it is only mentioned as Qabristan, Madhya Pradesh, Shashan. Unless it is dedicated to the Muslim community for any purpose recognized by the Muslim law, then implication that land cannot be said to be a Waqf by implication, and therefore prima facie it is not a Waqf property, then remedy for the party is not before the Waqf tribunal but before the tribunal court.
Yes, Mr.
My lord, in this para 18 and 19, the judgment which has been relied.
Number one, the land in question is not being used by the Muslim community.
No, my lord, we have already said in our plaint, as well as from the apparent from the page 19, my lord, what section 5 and 6, once it has come in the list of the Waqf, that would be a Waqf property.
This property is not being used by the Muslim community.
No, it is being used by, my lord. Therefore, we are before this honorable court, my lord.
This only court is that is.
No, relying on one Panchnama, my lord. My lord, it is to be decided. It was on the basis of one Panchnama. It cannot be said that, my lord, that the property does not belong to my lord. Because Waqf, section 5 and 6 of the Waqf Act says.
On this land in question,
my lord,
what your activities are going on?
Burial of the graveyard is there and burial proceedings is going on of the dead bodies, my lord.
So should we appoint the court commissioner to verify what is the position of the land?
My lord, it is registered for the right.
If you say that you are using,
yes, we are using. We have said in our plaint, my lord. If lordship
that can be clarified from appointing the court commissioner. He will go and file the report.
My lord, report can be called, my lord, if lordship may say my plaint, my lord. We have specifically said in para 1 कि प्रबंध व्यवस्था कब्रिस्तान अजयगढ़ भी आता है जो खसरा नंबर पे वक्फ संपत्ति के रूप में वक्फ बोर्ड में पंजीकृत है, जिसका मध्य प्रदेश राजपत्र में प्रकाशन हो चुका है. It is notified in the under section 5 and 6. Lordship may kindly see, my lord, of the Waqf Act. The limited order was there, my lord, that they were restrained that we are using it for that purpose.
Where this property is?
It is in Ajaygarh, Panna, my lord.
It's Panna.
District Panna, Ajaygarh is the tehsil place.
In para 21
my lord.
of the impugned order,
my lord,
it is noted by the Red Court that there is a fact-finding report and Panchanama that 0.32 hectares of the land was in possession and use of the members of Valmiki Samaj for burial of their deceased. Stop. Taking these facts into consideration, that the land is recorded as a government land, it cannot be considered to be Waqf property, especially when no document is produced by the appellants to demonstrate before the court to demonstrate registration of property as a Waqf property. Stop. Since there is no mention of property being dedicated to the Muslim community, and in column 12 of the Khazra entry, it is only mentioned as Kabristan, Madhya Pradesh, Shashan, unless it is dedicated to the Muslim community for any purpose recognized by the Muslim law, then by implication, that land cannot be said to be Waqf by implication, and therefore, when Pravaka case is not a Waqf property, then remedy for party is not before the Waqf tribunal but before the civil court. Stop. Counsel appearing on behalf of the appellant dispute the aforesaid facts and submit that. Which document you show that?
That is page 19, my lord.
Page 19.
That is a gazette notification.
A2.
Yes, my lord.
As per gazette notification, which is A2, right?
Yes, my lord.
A2. The property in question in the list of Waqf board. Therefore, the learned single judge has wrongly mentioned that there is no document on record whereby it is established that property belongs to Waqf board. Counsel for the appellant further submit that the property in question being used for the activities being used by the Muslim community for burial of
Yes.
their
My lord.
deceased. Stop. Keeping in view the aforesaid controversy whether the land in question being used by Valmiki community or the Muslim community, we hereby appoint Samhita, what is पूरा नाम आपका?
वर्मा अरोड़ा.
वर्मा अरोड़ा. तो एक दो और लगाते वर्मा अरोड़ा बजाज दी दैट. वर्मा अरोड़ा. Another senior counsel who is present in court and who accepted to be as a court commissioner.
Court commissioner.
Court commissioner. Stop. Accordingly, she will visit the site, file the report whether the property being used by the Muslim community or the Valmiki community for burial / cremation of their deceased. Stop. The state administration shall provide vehicle to her
Miles.
as and when she would like to visit this property.
Miles.
And these and vehicle. The state government shall also provide police security as required to the learned counsel named above. The party shall party shall pay we hereby fix fee of the council for an amount of rupees. कितना करें? 200 किलोमीटर यहाँ से जाना काम छोड़ के बोलो.
As my lord deems fit.
50,000 रुपए.
My lord, this petitioners, they are getting donation in Friday prayers. They are
डोनेशन में तो कुछ उधर डोनेशन
सब उसमें सर वो they are very poor society. They are just keeping watch on these only for graveyard, my lord. It's a matter of graveyard.
25,000 and to be shared by the appellant and the respondent equally.
Miles.
Stop. The fee of the court commissioner shall be paid within 2 days, and thereafter, madam, you will convey them when you are going to visit, and the court commissioner shall convey to the respondent state as and when she would like to visit, and accordingly provide the necessary arrangements.
There are private respondent number 1 and 2 also.
Sorry?
Is there? Private respondent number 1 and 2 who have been represented by the counsel, Mr. Suyash Mohan Guru. in the
They-
red petition, my lord. They are the counsel for the
They were the petitioners.
They were the petitioners, my lord. Respondent number 1 and 2 are the parties who have filed the petition initially.
The appellant and the state of Madhya Pradesh. आइएगा दोनों शेयर करेंगे एंड लिस्ट आफ्टर ऑन कर दो बोल के इस तरह मार्च 18 मार्च को 18 मार्च 18 मार्च
My lord, one humble prayer, my lord, that 2 days time may be extended to for 1 week, my lord. For deposit of amount, my lord. For 2 days, in place of 2 days, they make 1 week kar de, sir. My lord, there is a, meanwhile, the status quo, whatever exists today, be maintained by
Sorry?
both the parties.
The status quo shall be maintained for the party till the report received by this court from the court commissioner.